Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing prenuptial agreements and whether or not one can have two. What are we talking about here? Well, prenuptial agreements are an interesting document in law, and I'm sure folks watching this video are rolling their eyes going, yeah, to you, law nerd, we know you find it interesting. They're a contract, but they're a contract that occurs in a very specific set of circumstances, and it culminates in a plenary act which changes the status of the parties. What are we talking about, a plenary act? Well, marriage is a plenary act. It's the state saying, you're no longer single. This person is attached to you, not just legally. When they say the institution of marriage, it does supersede to some level legality. I put it that way. Now, it's not a huge deal in the sense that, marriage is something that's a very common, institutional thing. But long story short, it is very, very nuanced how you deal with things like prenuptial agreements. And I've seen folks that want to have two. They want to have one for Thailand and, one for the United States. The issue becomes, because the consideration for the prenup is the marriage itself. So the laws regarding prenuptial agreements where the marriage takes place is arguably, and I would argue strenuously, highly relevant to the nature of the marriage itself, because it is a plenary act at the end of the day. It's a plenary process, if you will. At the end of it, you've changed. There's something different about it. Just as a for example, naturalization to citizenship is a plenary act. At the end of it, once you are naturalized, you are a different thing. You're no longer what you were before. Similar with marriage. You're no longer single. You're now married. It's plenary. It occurs at a factual level, less so than a legal level. But the laws pertaining to that plenary act are highly, highly relevant. The point I'm trying to make here is, unlike with wills, and we've discussed this before, you can have a Thai will, a will in another jurisdiction, and there the twain shall meet, depending on how they're structured. Not so true with prenuptial agreements, because there's only one marriage. There's only one plenary act. And therefore, two prenuptial agreements, I'm not saying anything definitively here, because different cases, different circumstances are going to dictate different outcomes. But it's something to seriously consider when analyzing one's options with respect to marriage if there's multiple jurisdictions at play, because you want to be sure that whatever you have promulgated with respect to a prenup is in line with the law of the jurisdiction in which you're getting married, and is also not going to have any problems with any kind of conflicts of laws issue possibly in that other jurisdiction. And there are going to be certain circumstances where those two things are not going to align. Those two things are just going to be in conflict, and there's really nothing you can do about it. So again, that's something for folks to consider. In my opinion, in most cases, in the vast majority of cases, I would say, a single prenup is probably going to be the best. Again, there are circumstances where that may not be the case, but it's something to keep in the back of one's mind.